Next from Chicago, Governor Pat Quinn explains why he felt the concealed carry bill passed by the legislature had insufficient safeguards to protect the public. He lays out the changes he made through his amendatory veto of the bill, which allows an Illinois governor to make changes to the bill. This runs about 15 minutes.
It's an important day in Illinois. I'm the governor of our state, and I'm using my constitutional authority today to amend a bill that was passed by the General Assembly, House Bill 183. It deals with concealed carry. Explain that to the people of Illinois. It means that there would be an opportunity for citizens to have a loaded weapon concealed on their person in a public place. This particular bill was mandated by the Court of Appeals of the 7th Circuit on December 11th of last year, 3 days before the horrific tragedy in Newtown, Connecticut at Sandy Hook School. Our state was told by a federal court that we must adopt a law dealing with concealed carry. I felt that ruling was wrong then. I still feel it's wrong. It's not been appealed. We therefore have to take action to protect the public safety of the people of Illinois. And that's what I'm doing today. The most important job of a governor is to protect the safety of the people. And I've examined this particular bill over the last several weeks very carefully. And there are serious flaws in this bill that jeopardize public safety of the people of Illinois. And therefore I've used my power under the Constitution of our state to make important changes, common sense changes, to protect the safety of our people. I'm going to go through those specific changes because I think it's important to enumerate each and every one of those important changes that are needed in order to make sure that people of Illinois are safe. Number one, alcohol. This particular bill would allow someone to bring a gun into an establishment that has a liquor license and is serving alcohol. Guns and alcohol don't mix.
Right.
And I think it's very important that the legislature understand that message from the people of Illinois. And therefore, I took out of the bill any authority for an establishment that serves alcohol to allow guns in on its premises. Number two, in 1970, the people of Illinois in a referendum passed home rule. It was a constitutional amendment, a constitutional provision of our Illinois Constitution. It was hard fought. The people voted for it. And home rule is a very important part of life in Illinois. It allows local communities to adopt laws and ordinances that benefit their community. And that principle ought to be upheld. Unfortunately, this bill strips from home rule communities all across Illinois their authority to enact future laws on assault weapons, and I think that's the wrong way to go. This provision was inspired by the National Rifle Association. It has nothing to do with concealed carry. It's part of their agenda, no doubt about it, but we don't need the NRA telling us how to keep people safe in the state of Illinois and our local communities. Under this provision of this law, guns are allowed to be brought into stores, to restaurants, to churches, to children's entertainment venues, to movie theaters, and other private properties. I think it's very important that the owners of private property, owners of private property, be allowed to ban guns from their premises without having to post signs saying no guns allowed. The presumption ought to be that no guns are allowed in these places. And if an owner wants to have guns, then they should have to have a sign that says guns are welcome here. It shouldn't be a burden on private property owners to put a sign otherwise. The number one cause of workplace fatalities in our country are shootings in workplaces. And under this provision of this House Bill 183, employers are not given the ability to properly have a safe and secure work environment. Too often there are situations where guns can be brought into the parking lots of workplaces, and we want to make sure with our change that employers are given full authority to prevent employees from carrying guns into the workplace or to the adjoining parking lots. Now, a very important issue, and that has to do with high-capacity ammunition magazines and the number of guns one can conceal on their person. Under this bill, the number of guns that can be concealed on your person is unlimited. It is not limited to one. You can carry multiple guns on your person, and you can have multiple high-capacity ammunition magazines on your person concealed. This is a public safety hazard, and we need to make sure that the people of Illinois come first when it comes to safety. So we have clarified this provision of the law and limited it to one gun and one ammunition clip that holds no more than 10 rounds of ammunition. We've already seen what's happened elsewhere. Mental health reporting, which is very, very important to make sure that guns do not fall into the wrong hands. There is a lack of clarity in this bill on the notification process. I've clarified it to make sure that our guns across Illinois do not fall into the hands of those who should never have them in the first place. Finally, another issue has to do with the whole definition of concealed. Under the bill, if you read it, the definition of a concealed firearm includes the phrase mostly concealed, not fully concealed. It allows licensees to walk in public with a portion of their gun exposed. This isn't conceal at all. Therefore, this insufficient provision, which does not properly conceal the weapon, must be clarified. It must be completely concealed. That also deals with the issue of who should have these licenses. There is a provision in the law that allows law enforcement to challenge someone's right to have a concealed carry license, but the appeal board, which is called the Concealed Carry Licensing Review Board, is entirely exempt from the Open Meetings Act, from the Freedom of Information Act. That is not right. Right now we have a prisoner review board and an emergency medical services disciplinary board that deal with the very important issues, but the records of those boards are open and public, available to the people of our state. And so I've clarified that as well to make sure there's more transparency with respect to who is getting a concealed carry permit. Finally, our law enforcement every day, they take their life in their hands to protect us, our public safety. We want to keep Illinois safe, and we want our public safety officers to be safe. So under the provisions of the bill that arrived on my desk, there is no requirement that someone with a concealed weapon on their person immediately disclose that to a member of law enforcement upon request. We must require that immediate disclosure. I think this is an example of a situation in Illinois where the legislature passed a bill in a hurried way at the inspiration of the National Rifle Association, contrary to the safety of the people of Illinois. Fortunately, our Constitution, adopted by the people in a referendum, gives the governor an opportunity to propose important changes that protect the public safety. Our motto is Keep Illinois Safe, and we have a website, keepillinoissafe.org, that people can visit to see this bill and to see the changes we have proposed for this bill. I think it is important in the coming week that people across our state have the opportunity to look carefully at what the legislature has proposed, what I have changed in this bill to make it safer for the people. We ask the people of Illinois to tell their legislators, please support the common sense changes that I have made in this bill. We don't think alcohol and guns ever mix. No. And I think most people in Illinois, most people agree very strongly with that provision. We don't think that those who want to have a concealed weapon on their person need multiple concealed weapons with high-capacity ammunition magazines concealed on their person. I think it's time for all of us to come together in the best traditions of democracy and make sure our voice is heard in Springfield by the legislature. This is the amendatory veto of today, and I think over the next week, the people of Illinois need to study our amendatory veto, see these common sense changes. I now want to bring forward someone who has worked on this issue for many, many years, who is with us here today, Colleen Daly from the Illinois Council Against Handgun Violence. Colleen, come on forward.
Thank you. My name is Colleen Daly. I'm the Executive Director of the Illinois Council Against Handgun Violence. Let me begin by saying, Governor Quinn, thank you very much for your tremendous leadership on the issue of gun violence prevention. There is no question that the Illinois Council Against Handgun Violence was staunchly opposed to the carrying of concealed loaded handguns in public places for many, many years. And while we were not thrilled with the court's decision, we respected the decision and worked hard this past legislative session to pass the most comprehensive concealed carry law that will save lives in the country. Unfortunately, that did not happen, and a flawed bill was passed. Thankfully, our state's top elected official, Governor Quinn, has our back. We have far too many people in this state. In fact, 1,000 people each year in Illinois are killed by guns. Yet we have far too few people willing to take a stand to pass the kind of common sense gun laws we need to save lives. So again, thank you, Governor Quinn, for your leadership, from everyone we represent at ICHV. While House Bill 183 had some good provisions included in the bill, we believe it goes too far, and the governor's amendatory veto will address many of our concerns. In particular, we are pleased that the governor is removing the arbitrary and, quite frankly, ridiculous deadline on communities to pass an assault weapons ban. We are pleased that he shares our position that alcohol and guns simply don't mix. And we're happy that he's requiring businesses to assume that concealed carry is prohibited on their property unless appropriate signage is placed. And lastly, that he is restricting the concealed carry permit holders to carry magazines with 10 rounds of ammunition or less. As the legislature will likely soon hear the governor's veto, it is very important that we think about what has been said. The NRA's argument has been this entire session: Illinois should pass concealed carry because 49 other states have it. Our argument has been, yes, 49 other states do have concealed carry, but if we have to pass one, let's make sure we learn from their mistakes. We have seen the evidence. We know that putting a CCW permit in the wrong person's hands can only enhance the chances of a deadly incident taking place. Look no further than the fact that since 2007, at least 516 people have been killed by people carrying lawful concealed carry permits. That includes 24 mass shootings and 14 law enforcement officers. We believe that it's a matter of life and death for Illinois citizens who are already too burdened by the toll of gun violence in our communities. We believe that the governor's changes are extremely reasonable, and we strongly urge the Illinois General Assembly to accept his amendatory veto. Thank you.
Okay, thank you, Colleen.
You're watching the Illinois Channel, an independent nonprofit corporation formed to provide gavel-to-gavel coverage of Illinois state government and other public affairs events taking place across Illinois.